Hi friends, hope you're fine and doing well. Today we are going to discuss a very important concept which has been embodied under section 11 of CPC known as res judicata. This is considered to be the toughest concept, most difficult concept as far as the law students or the legal fraternity is concerned. But my dear friends, I just assure you that after 10 minutes from now, you will find it more interesting, more simple, and the subject wherein you will be able to relate yourself. And you would really admire and appreciate that lawmakers have come out with such a beautiful provision, which not only provide a safeguard to the litigant, but also prevent the courts their precious time to be wasted. Now, let's understand the whole concept one by one. So, in the coming 10 minutes, we will be discussing as to what is the meaning of this term. What is the importance of this term res judicata? Why it has been incorporated under CPC? What was it need? What are the principles behind it? And what are the essential conditions to invoke these principles? So all these things we would be covering in the next 10 minutes. So let's understand the meaning first. Res means subject matter and judicata means things which have already been decided upon, already adjudicated upon. Meaning thereby the matter, issue, things, claim which has already been decided upon by the court of competent jurisdiction should not be allowed to be re-agitated or re-litigated again. This is the concept. Suppose you file a suit and suit is decreed or suit is not decreed in your favor. Now you are not supposed to litigate the same subject matter again in the subsequent suit either before the same forum or any other court of law in India. Now what is the logic and rationale behind this? One, that to ensure the fairness of administration of justice, it is very important that the decision rendered by the court of law of a competent jurisdiction should be accepted, acknowledged, recognized, honored as a true decision. One. Two, one who has already been subjected to a prolonged litigation should not be subjected to the same peril again. He should not be vexed twice for the same cause or the same matter again before any other forum. And third, the most important thing is that it is always in the interest of state that there should be an end to litigation. Now friends, you need to understand as to why. If this provision will not be incorporated, then all rich and the affluent people would be in the position to abuse the process of law. They will not only suppress or exploit the weaker section, but also be in the position to take leverage on account of their wealth. So the weaker section of the society should not be subjected to any kind of atrocity anymore, and rich and affluent who are in the position to make mockery of law, they should be dissuaded, discouraged to do such things. So there are three principles which are based on the Latin phrases. One of the phrases, nemo det lis vexeri pro uno ad idem causa, which means no man should be vexed twice for the same cause. Second is that interest republica ut sit finis litium. It is in the interest of the state that there should be an end to litigation. And third is res judicata pro veritable occipitur, a judicial decision must be accepted as correct. The student of law who have been preparing for any kind of competitive exams, I would suggest them to read it, reread it, memorize it, and whenever the question comes as to the principle of res judicata, they need to incorporate in the answer the three terms, the Latin phrases and their meaning very clearly. So these are the three embodied principles on the basis of which this concept was evolved to safeguard the interest of the litigant and to prevent the precious time of the court. Now, what does it ensure? This concept ensures, one, that adjudication which has already been taken place, it could be relied upon. Fine. So you can say that it encourages the reliance of an adjudication. Second is that cost of the parties, the inconvenience and the hardship which is going to cause to them in the further litigation, that could be saved or they could be prevented. Then vexatious and multiple suit, the vexatious litigation could be discouraged, and judicial process that could be conserved, and last but not the least, an inconsistent or conflicting judgment of the decision could be avoided. Fine. So these are the few things which are very important when you discuss the concept of res judicata and when you give the reasoning or the logic as to why it was incorporated. So my dear friends, a student of law must satisfy his why first, while he has been preparing for the subject. So if you really want that the administration of justice should remain intact and fair, then there has to be an end to vexatious litigation, fine, which is always encouraged or the always initiated by the people who are mighty and affluent one. Fine. A very important decision which you have to quote, that is State of UP versus Nawab Hussain. What has happened in this case? A dismissal was challenged by the Nawab Hussain on account of the fact that he has not been given a reasonable opportunity of being heard. But his argument were negated and the petition was dismissed by the High Court. Now again he filed the other petition stating that his appointing authority was in fact an IG and he could not implead the IG in the other petition, and therefore this could be entertained and he should be heard again. Now the learned trial court and the Honorable High Court, they did not bar the second petition on account of res judicata, but the Honorable Supreme Court held that the second petition is barred by principle of constructive res judicata by holding that as it was within the knowledge of the plaintiff at the time when he instituted the first petition and the plea was available to him, but he failed to take it. So therefore his second petition could not be entertained. So my dear friend, the constructive res judicata, the plea, it says that if the plea was available to you or you could not take it at that stage, that on the basis of the same plea you cannot institute the second petition. So there has to be one, the former suit which has already been decided by the competent court on merit, and there has to be subsequent suit on the same matter, same issue. Fine. So we now will see the conditions as to in order to invoke the principle, what are the essential conditions which one is required to fulfill. So one of the condition is that the matter directly and substantially an issue in the subsequent suit or issue must be the same matter which was either or actually or constructively in the former suit. So if the matter in the previous and the subsequent suit is the same, then the principle of res judicata would be invoked. Second is that there must be, the second suit must be between the same parties as between the parties under whom they or any of them claim or litigated. Fine. The parties to the suit in the subsequent suit should be the same as of the former suit. Then court who has rendered a decision must be a competent court of jurisdiction. It is not that the court which was not having a jurisdiction, fine, it rendered the verdict. So the decision which has already been given, it has to be on, and the last one is that it has to be on the merit. Matter must have been heard and finally decided, means the merit of the case must have been touched. The arguments, the facts and the evidence must have been appreciated by court of law earlier, and the reasoned judgment should have been pronounced, fine, with regard to the matter in the controversy. So then we can say that under such conditions we can invoke the principle of res judicata. Now it is also known as the rule of conclusiveness of judgment only on account of the reason that once the judgment is given, pronounced, it becomes conclusive. So it is also known as, and it can be challenged by way of appeal, but by way of another suit it cannot be challenged at all, and it would be barred by the principle of res judicata. Fine, my dear friends, I think I have been able to clarify each and everything as to why this principle was invoked, and I think you would now agree with me that this is one of the finest provisions or a concept which has been incorporated under CPC. I think it is enough for today. I hope I have been able to clarify. Thank you very much for hearing me patiently.